Hi, everyone. Welcome. We're going to get started here in just a few more minutes. Probably a few more seconds, actually. So welcome to our webinar, What Flexibility Exists in IDEA. This webinar is presented by the Learning Rights Law Center and the Learning Disabilities Association of America. I'm Cindy Cipoletti, the Executive Director of Learning Disabilities Association of America, and welcome to our webinar today. Just a few housekeeping things to go over very quickly before we get started. Everyone is going to be on mute for the main portion of the webinar so that the focus can be on whoever is speaking. We will be taking questions at the end of the presentation. If you're connecting via phone, please press *6 to unmute yourself, but ensure that you're not on speakerphone when you do this. We will remute you if you cause feedback when you unmute yourself. If you're connecting via the computer, please type your question in the Q&A or chat boxes. We'll be gathering these throughout the webinar for the Q&A session at the end so they can be typed in at any time. If you sent in a question ahead of time to info@ldaamerica.org, rest assured we have this and we'll be presenting those questions to our speakers during the Q&A. Erica Pardoon is our technical person behind the scenes, so if you're having any issues at all, please use the chat to send her a direct message. Unfortunately, for those of you on the phone, we're unable to troubleshoot phone connections at this time. There will be a replay of this webinar sent to all registered attendees within 48 hours of the webinar, barring any unforeseen technical difficulties. So with those housekeeping rules now behind us, let me just tell you a little bit about Learning Disabilities Association of America and our speakers today. LDA has been actively involved in helping children and adults with learning disabilities since 1964. Our mission is to create opportunities for all people with learning disabilities through support, education, and advocacy. During this COVID-19 pandemic, with the closing of schools and the switch to online and remote learning, one of the topics that's become widely debated is what flexibility exists in IDEA and whether waivers are necessary. So today we have with us 3 experts in special education law who are going to answer some very important questions about IDEA's flexibility. Janine Steele is the founder and executive director of the Learning Rights Law Center, a nonprofit organization that provides legal services to disadvantaged students not receiving an equitable public education. Heidi Goldsmith is a special education attorney with 20 years of experience serving the needs of children and families, and is also a member of LDA's Professional Advisory Board. Our third panelist is Andrew Faust, a partner at Sweet, Stevens, Katz & Williams, and a widely recognized authority in the area of special education. So thank you all for being here and your willingness to share your knowledge and expertise on this topic. Also with us today is Monica McHale-Small, who is LDA's board president, and having been a former school superintendent and an adjunct professor and consultant to the PA Department of Education, Monica is certainly an expert in this field as well. So before we get started with the webinar, we have a quick poll that we would like you to participate in so we know who our audience is today. So if you could just tell us what best describes you. We recognize that many of you may fit more than one of these, but if you could kind of just pick the one that you are in at your capacity today, joining us for this webinar, that would be great. The way we will conduct today's discussion is that Monica or I will direct a specific question to one of the panelists, and after that panelist gives his or her answer, the other 2 panelists will have an opportunity to weigh in on the subject. These are questions that LDA has gotten directly in the past from parents and educators, or that have been shared with us from others in the field of special education. As I said before, we also had some questions that were emailed to us in advance, and we will do our best to address those questions as well. So just a few more seconds for the poll, and then I think we can show what those results are. We'll wrap that up, and then, okay, so we kind of have a good blend of different people represented here today. So that's great. All right, I'm going to turn it over now to Monica, who is going to start us off with our first question.
Hey, hello everyone, and thanks for joining us today. As Cindy alluded to, this is a topic that's near and dear to my heart as someone who is currently in the business of advocating for individuals with learning disabilities and other disabilities, and because of my background in education as a school psychologist and a superintendent. So I had a feeling this would be a popular webinar, and it looks like my feeling was correct. So thank you to everyone who has joined us today. And our first question, I'm going to direct it to Janine, and then how we're going to do this is that we're going to make sure that each of the attorneys has an opportunity to weigh in. And if we do not get to all your questions, I just want to let everyone know that we will be creating a Q&A document that we will share on our website. So don't feel badly if we don't get to your question. So Janine, in advocating for IDEA flexibility, there are some professional organizations that represent school district administrators that contend that because no one anticipated a pandemic when IDEA was crafted, that any flexibility that currently exists in the law is not relevant to our current situation. How would you respond to that thinking?
I would respond that, no one thought that this could happen. There's a lot of laws and protections for disability rights in general and civil rights laws, but those aren't like suspended because there's a pandemic. The flexibility embedded in IDEA is there and is incorporated also in the reports from the Office of Civil Rights, Department of Education, and the Department of Education documents that they produced after the pandemic happened, when students went on distance learning. So while I understand that this wasn't a thought at the time, but there's a lot of things that are not thought of at the time of any law. And I think that the law is very clear on how to address students with disabilities, how to be flexible, what you can and can't do. So just because the law wasn't enacted, a pandemic wasn't thought of at the time that the law was enacted, doesn't mean that the flexibility disappears at the time right now. So all that flexibility is gone. So I don't know how Heidi or Andy would respond.
So this is Heidi. I agree that first of all, there is no, as I would tell clients, no pandemic clause in the IDEA. However, the great thing about the IDEA is its inherent flexibility in helping students with disabilities. Specifically, if you look at some of the regulations specific to the continuum of placements, it talks about in-home instruction. It talks about placements in hospitals. So the idea that learning could only happen in a school-based setting, I think the IDEA already envisioned that there should be a variety of placements that education can happen. I mean, if you just look at the fact of the start of cyber schools, the whole idea of virtual learning in special education applying to those students has been around since at least a Dear Colleague letter put out by OSERS on August 5th, 2016, that really talked about the fact that even if a student is in a virtual learning circumstance, that all the FAPE provisions apply. And as we all know, virtual learning has been around since the early 2010s at least. So I do think the great thing about the IDEA is the flexibility that was crafted to allow for all these different types of learning environments to occur so that students with special needs could still receive FAPE during the time that they are in different placements. Andy, I don't know if you have anything to add.
Well, yeah, I mean, first of all, I'd point out that the IDEA is well past its expiration date. It was supposed to be reauthorized in 2009, so we're 11 years beyond that point. In 2004, we didn't have anything remotely like the cyber environment we all exist in today and take, quite frankly, for granted. So the IDEA is badly out of date to start. And second, the flexibility that everybody seems to suggest exists in the law simply is not opposite to the environment that we're in right now. Yes, Heidi, it is true that students are expected to be educated where they are. So if that's in a hospital because they need to be in a hospital, or if that's in the home because their disability uniquely requires that they learn there, yes, the IDEA would expect that the child be served there. The IDEA does not expect that the entire cohort of learners is going to be unable to come to a brick and mortar setting. Moreover, while I think your point about cyber education is well taken, it should be noted that Pennsylvania's cyber charter schools, where you and I, Heidi, both are expected to fulfill the complete FAPE mandate for students who are learning online. And that often means that cyber charter schools are supplementing virtual learning with actual learning, whether that's in a brick and mortar setting or by importing staff members into the home to assist the learner in accessing their virtual learning. That simply can't happen now. We are in an environment that even for experienced cyber educators is extraordinary and unanticipated.
Thank you all for that. Okay, so the next question that we are going to direct for Heidi, and then give Andy and Janine an opportunity to weigh in. Heidi, some school officials believe that in order to provide remote learning to students with IEPs, it is necessary to reconvene the team to revise the IEP. Because they do not have the human resources available to hold all of these IEP meetings, they believe IDEA waivers are necessary. How would you respond?
Well, again, in looking at the IDEA as it currently exists, and I don't disagree with, Mr. Faust that, it has been a situation, it's been a long time since it's been reauthorized, but the IDEA did allow already for waivers of team members upon joint agreement among the parties. And again, I think this is one of those time periods of where that communication between the districts and the families really do need to occur. I mean, if you look at parental participation and other participation of team members, the IDE already envisioned that these meetings could happen virtually. So, I mean, if you look to 300.322C, parents could already attempt to participate in these IEP meetings virtually. So I do think that there is no reason that you can't have IEP meetings. I mean, I will tell you, and Andy and I are both in Pennsylvania, but I would say I participate in 2 to 3 IEP meetings a day at this juncture for students. And again, we're waiving team members, but it is a situation where these meetings can absolutely occur. I don't think you need to revise the IEP. You may not need to have all the team members there. And again, the current IDE as it exists allows for a teacher and a parent to meet to make minor revisions to the IEP. In the state of Pennsylvania, interestingly, there was an act passed that actually required districts already to issue notice to the parents of what the distance learning is going to require, not necessarily an IEP team, but at least what we consider as a notice of recommended educational placement. In other jurisdictions that might be known as a prior written notice, but at least communicate with the parents. This is how we are going to be providing the distance learning during this kind of unprecedented time. And Andy, I don't know if you had anything else on the thought process.
Well, yeah, I mean, there is no question that if we strictly look at the IDEA, it would require that any change in the free appropriate public education of a child would require the intercession of an IEP team meeting. But if you look at an even relatively modestly sized school district of 4,000 students, with the average identification rate we have here in Pennsylvania of 16%, you would be talking about 640 IEP team meetings that would need to occur if you were to operationalize that as a requirement to the delivery of home services. That's simply not realistic. So we've had to be pretty creative about almost inventing our own waiver, if you will, by not interpreting what is going on here, the virtual learning that we are offering and implementing, as the child's fate. It is a means of making a good faith effort to deliver the FAPE, which exists in the existing IEP. We use, as Heidi has indicated, prior written notice to give the parent a good and specific understanding of how it is we will attempt to implement that FAPE, but we're not actually changing the FAPE in doing so. So we've not had a lot of IEP team meetings here in Pennsylvania.
Janine, did you want to weigh in on that as well?
Yes, very, very quickly. I think that I don't necessarily think there has to be an IEP for every student on a distance learning plan or creation of it. I do think that it's necessary right now to hold the IEPs that you would typically hold, whether they're annuals, et cetera. I also think that we have to be individualized, and students are facing additional obstacles, and you can't just ignore them. So parents are, if they need parent training, they need, teaching about the technology. There's a lot of reasons to actually hold those IEPs. I agree that you don't have to have all the team members if everybody agrees. And if parents agree, there can be amendments, but there's a lot of parameters regarding that. But I think that there's a lot of ways to do this without having an IEP for every student, but also making sure that they are held for students that may have changing needs as a result of the pandemic as well.
Okay, so just jump before I move on to the next question. One of the things that we're hearing from some, again, LDA is a national organization. So we are hearing from some parents that some districts have taken the position that they will not provide any services until they can actually convene an IEP team. It sounds to me from what our three panelists is saying that none of you would agree that that would be the case. Am I correct in that?
Yes.
Correct.
I would agree.
All right, great. Okay, this next question, I'm going to start with Andy. And this it's interesting because, again, it's a little bit related. You talked about in an earlier answer how we can't really go into the home to deliver some of these direct services to students. But in some states, there are folks going in some states where the lockdown requirements are not quite as significant. People are going into the home. Other places they're delivering therapies via Zoom, or in other places they're just doing it through worksheets and other things. So what has been discussed, or what are you aware of regarding best practices during this COVID-19 situation regarding the delivery of speech, OT, and PT services?
Well, I'm going to start this under the assumption that, like here in Pennsylvania, we don't have the flexibility of providing in-person service going into the home. Right now, that would violate the social distancing and school closure orders of the governor without question. So I'm going to assume that when you ask this question, the question really is what are the best practices, or what are the recommended practices for delivering this kind of service when you can't actually be with the child? Certainly, telepractice is something that has been evolving both nationally and here in Pennsylvania pretty rapidly in recent years anyway. Many public schools are resorting to telepractice as an option to live practice. It is approved for medical assistance reimbursement. It is approved for school-based medical assistance reimbursement here in Pennsylvania now. So it's not a model that is without precedent even before the pandemic. There are some cautions that I would add, particularly when we're talking about a related service that involves physical manipulation of the child, as physical therapy and some occupational therapies will. If we don't have a parent who is able, willing, or can accept training to provide the kind of manipulation and hand-on-hand support that may be necessary at the direction of the distance located therapist, we're not recommending proceeding with therapy under those situations, although we are recommending trying to train parents to be partners where they're willing and able to do so, and that's necessary. A second concern that some have presented is you are effectively delivering service one-on-one in an environment that is unsupervised by any adults, potentially. And there are some questions about the possibility of allegations of inappropriate conduct by the therapist. To address that, some districts are, and I don't think this is inappropriate, either recording the sessions to maintain confidentially a record of what occurred, or they are having a second person accompany the online therapy as it's being delivered.
Okay, Janine, did you want to?
Yeah, I think what we've seen is very sporadic in California about the delivery of related service. I think that the telespeech and telecommunication, I actually think that that is the way to provide it. I think that working with the families becomes key, and making sure that they have the right training and the right equipment. Because, you know, providing speech therapy by a cell phone may not be appropriate, or by phone. So we have, you know, parents that have access to information and technology. We have a barrier right now. And I think there is no reason not to have a lot of the, sorry, the alarm is going off, is is to make sure that students have access to the related services. I think the related services are one of the areas where you can provide the service relatively fast, and we've seen that. And I don't think there should be a delay in those, but I think that the providing teletherapy is the best way to provide those services. It's time.
Heidi?
And I would agree. I mean, I think the best practice is teletherapy. I also completely agree with, Andy in regards to the fact is, the IDE does allow for parental training. And I myself have actually had my child with significant speech issues access that parent training to be able to learn the speech therapy techniques, because as we all know, most of these things, speech, OT, PT, happen everywhere. It's not just in a isolated, situation. So the more that parents can learn those strategies to be able to continue those services beyond the speech time is not just important now, but, candidly all over. I will tell you, unfortunately, teletherapy is not necessarily the norm. My son receives speech. He's receiving no speech teletherapy and is actually only receiving pre-recorded videos not specific to him on different speech techniques. So, and I was told it was because of union issues. So I think the difficulty is with everything that's occurring is there's no standardization among what kids are receiving. So what kids are receiving in one district, another child in another district's not receiving it. So I would hope that there would be more outlining of what best practices are for all districts, across the nation, so that we're all kind of operating under the same, handbook.
Great, thank you. So the next question I'm going to direct to Janine first. How are districts progress monitoring when access to students is limited? What data is appropriate and legally defensible regarding progress monitoring during COVID-19?
I think that if you're providing whatever instruction you are providing, the students' IP goals have not disappeared because there's a pandemic. You still have goals, you still have services, and you still have a plan, and that plan is being implemented at however it's being implemented, and you can progress monitor that. There should be no reason why there can't be communication with the parent, with the providers to find out how that is done, and you can create the same kind of measurement and provide notice to the parents, because they need to be aware of what's happening. Right? No progress monitor isn't helpful, because at some point there is going to be a return, we hope, to in-person learning. And adapting the instruction. So you need to know how the student's doing right now, because that will also tell you how they're progressing and if you need to adapt to a different kind of program, even in a distance learning program.
How about Heidi, do you want to weigh in on that?
Sure. I really thought about this because I think initially my reaction was obviously you could progress monitor, because the fact is, if you're looking at a fluency goal for reading, you can have the child read over the internet to the teacher. But then when you looked at some of the goals, such as social emotional, socialization goals, study skills, I do think that those tend to be harder to progress monitor. I think, you do the best you can, for example, if your child with social emotional needs, maybe it's when they're meeting with the emotional support teacher, they're able to identify any situations that came up over the week, and they're able to talk about strategies they may have used, or even talking about what strategies they could use. But I also think this kind of goes to the fact that when we get back to more traditional school-based setting, I do think these kids are going to have some sort of data points taken so that we can kind of assess where the kids are, because any idea that a child has either stopped learning or continued to learn, I think during this time is going to be an unreasonable expectation. So I think that some data is going to be easily obtained, other data we might have to be creative of, but I think most important is when school is back in session to absolutely get data on where the child is in those goals.
Andy, you have any thoughts on this?
Yeah, I mean, look, one of the messages that we've given to all of our district clients is we're going to have to accept that there is a fate mandate that remains unmitigated and unwaived, hanging over our heads in an environment where we simply can't meet it entirely. And our efforts here have to be aspirational. We have to come as close as we possibly can to delivering FAPE, one of the components of which is progress monitoring. If we can progress monitor, great. If we can't, and we have to make grim choices between things like delivering quality instruction and progress monitoring it, I would prefer that we're delivering quality instruction. If it comes down to whether we're doing things in a timely manner or doing progress monitoring, I would prefer that we're timely. So hard decisions have to be made with a faculty that is working from home, dealing with their own children and their own demands in addition to their teaching responsibilities. So we'll do the best we can. I'm with Heidi 100% on the idea that when school resumes, we're going to have to re-baseline every child and every goal and provide some form of recoupment instruction to truly understand what the effect of this interruption in learning has been on kids.
Okay, well, Andy's last comment then was a nice lead into the next question, which is like the $1 million question, which we got from a number of people. What are districts' legal vulnerability for Comp Ed as a result of COVID-19? Will providing Comp Ed services be enough to reduce the legal vulnerability? And we'll start with Heidi on this one.
So this is actually the $1 million question. And I know that Andy and many of his cohorts truly believe that us parent attorneys are breathlessly awaiting, pouncing on school districts the minute that school is back in session, complaining over everything that was not provided. You know, I've had the pleasure of speaking with Andy in the past. And one of the things I'll never forget that he absolutely told to a room full of school district administrators is the IDEA is not a performance guarantee. That basically you have to come back, you have to reassess, you have to try. And I think that that's where the vulnerability truly lies for districts at stage one, which is what did they try to do? I think if you took a district that did nothing and offered nothing to kids, I think those districts are very vulnerable, you know, because you do have districts who are trying very hard. I represent a child where the child has no means of electronic resources. The family only owns a cell phone. There's not even internet in his area. I have a teacher calling the student, and this was the district offered, to call the student 2 hours a day, read the instruction, you know, answer the questions. I don't think that district's going to face much liability. So I think what a district is doing is going to come into play. You know, from a legal standpoint, because, you know, we are lawyers, you know, there is the closest case law I could find was ND versus Hawaii, which was a Ninth Circuit decision. And that involved a situation where the whole state was under a financial crisis. And they ended up having to close the state for every Friday. They furloughed everybody. And, you know, the court basically said that they're not going to hold what the state was doing as a violation of the IDEA. And they basically said, you know, if it's a situation that's impacting everyone, if things change for children with disabilities as well, that's not necessarily a violation of the IDEA. I do think what districts are going to have to do, and I have not heard any different from any school district attorney, which is when they come back, if they were unable to provide services, or the child has regressed significantly, they're going to have to provide some sort of compensatory services. I do think that from a legal standpoint, it is interesting that we're not using the term compensatory education, and all the documents don't use the term compensatory education, but compensatory services, because what I'm seeing is an envisionment is that these services are going to come from the district, not a traditional Comp Ed, you missed an hour, now you're entitled to an hour. So I don't agree with Mr. Faust that all his parent attorneys are just waiting and wait to pounce on the district. And candidly, I don't think the courts are going to hold districts as long as they made good faith efforts, legally highly responsible for huge compensatory education claims during this, you know, crisis that we're all experiencing.
Andy?
Pennsylvania schools closed on March 13th. That afternoon, it was a Friday, I remember very distinctly, 2 parent law firms in Pennsylvania posted advertisements, for want of a better word, on their websites, reminding parents of the right to compensatory services and of the district's obligation to ensure FAPE. Now, one could argue that this was a public service announcement and they were simply letting parents know what their rights were. But the fact that they were on a law firm for hire's website would suggest perhaps that my fears may not be all that unfounded, Heidi's assurances to the contrary notwithstanding. I will point out, however, that Heidi is absolutely correct, that there are two different terms in play here, and they really do need to be distinguished. Compensatory education is a remedy that is awarded, particularly here in Pennsylvania, rather aggressively, by hearing officers when they have found something wanting in the school district's free appropriate public education. And as Heidi correctly points out, those services are typically awarded hour for hour. So for every hour a child was denied appropriate reading services, a compensatory hour is awarded. Moreover, here in Pennsylvania, typically our hearing officers monetize those hours. So they will allow parents to go out on the private market with each hour of compensatory service awarded and purchase services that they deem appropriate, parents deem appropriate to remedy the problem. I believe compensatory services, as the United States Department of Education has in mind, really are in-kind services that districts are going to have to consider for every child to determine what, if anything, will be necessary to make that child whole as a result of any loss that might have occurred during the pandemic. And Heidi's correct that the degree of loss is going to be proportionate to the degree of effort that was expended by the district during the break to ensure that kids were still learning and still engaged. So we'll see how that all plays out, whether it is the disaster that some are expecting or a blip on the radar screen that others may think it will be. We'll see.
Okay, Janine?
Yeah, just really quickly, I agree with the analysis that I think it's the amount of effort and what the district is doing now to address the students' needs in the IEP. I do think that what we saw was a delay of not providing anything until DeVos wrote that letter. I was literally on an IEP that said, oh, now we have to provide something, and we will starting now. And so even with that, even if there was a delay, I do see judges saying we're in this really interesting situation. We know that everybody's trying to figure it out. But I think the two things I would say, one is to make sure that students with disabilities are not being treated differently, and that is a concern, is that where there is potential for discrimination here, and the discussion that it goes to, we want to waive all this, that feels, as a practitioner, as a civil rights activist, feels a little discriminatory with this push of like, we don't want to do anything. We just shouldn't have to abide by anything. So I think that language has to shift to be, how do we do it? Because I agree with Heidi. We work with a lot of families, and we train a lot of families about how to work with the district, and this is the time and the opportunity that districts have to, one, mitigate any liability by working really closely with families, providing that parent training that's really been lacking for a long time. And when going back to school, be holistic and talk about what a child needs, what are their needs now, because no one knows the effect and fear that we're all going to face by when we're entering into a more communal, or, in an environment that's going to be very different. So, and a lot of our clients have issues with change. And so we know that school districts are probably going to have to do more when kids come back. And that's completely separate from any liability for compensatory. So I think I agree and understand, but I think there's a lot going on that we're going to be walking through, everybody.
And before Cindy goes on to the next question, I just want to kind of highlight something that Janine said, and actually all three of our panelists have said, that, IDEA has always mandated collaboration with parents, training for parents, and perhaps a silver lining in this situation is that this is a time where school districts can really step up and provide that training, because certainly many of the folks who are reaching out to us at LDA are having those struggles, just as a parent trying to navigate all the systems that are being utilized to provide remote learning. So certainly this is a time to revisit that parent training and collaboration piece. Cindy, do you want to go to the
Sure.
next?
So the next question, Andy, we'll direct this to you first, and then Janine and Heidi. So we've heard of at least one school district that directed school psychologists to finalize any evaluations that were in process with the data they had available, but to conclude that all students were ineligible because school closures made it impossible to rule out lack of instruction as the cause of a student's difficulties. What are your thoughts on that? Oh, you're muted. Andy, you're muted.
I was going to say, concrete rules like that drive me insane because they rarely lead to good things. I mean, we have advised all of our clients that there are a couple of kinds of evaluations that absolutely must be brought to completion during the period of shutdown. One is an initial evaluation for which we received parent consent. We have a federally mandated and state mandated here in Pennsylvania 60-day timeline running from that trigger point that is not waived. So we need to culminate that process with an evaluation report that summarizes whatever it is we were able to gather about that child during that period of time. The same thing is true, by the way, of 3-year reevaluations that are coming due during the period of closure. Again, no waiver for the completion of a 3-year reevaluation process unless the parent agrees to waive the entire process, which the IDEA allows. So we have also recommended that those be brought to conclusion. Obviously, in both cases where no testing was possible, that is going to have to involve a summary of all existing data that we have available on that child. And certainly there should be that, unless this child was being evaluated as a brand new student, which is highly unlikely at this point in the school year. There should be existing data that can be used. It is true that in an awful lot of initial evaluations, given the criteria necessary for establishing IDEA eligibility, that teams might have to conclude that they are unable to reach a conclusion about eligibility, in which case they're going to have to defer ultimately to a time when we can do testing, the ultimate determination of eligibility. However, if we can make a provisional determination based on how that child has responded to instruction to date, how that child has behaved or interacted in the learning environment, if there is any provisional diagnosis that can be made, we are recommending that teams do that with the understanding that considerable refinement may be necessary in a subsequent evaluation once schools reopen. But we're not excuse the obligation, and we shouldn't make a general rule that suggests that every child should be non-qualified when we have data that may enable us to apply one of the IDEA labels provisionally.
Janine, what are your thoughts on that?
I agree, no blanket rules. Also too, the school closures have only been like in the past, what, 6 weeks, 7 weeks? Most children were in school prior. So the lack of instruction argument to me as a lawyer that would represent parents doesn't exist. And so that if there's a reason that to make that argument for some other reason, but the time out of school is not gonna hold up in my opinion. I also think that I agree that there's existing data. What do you have now? And there is no reason to not speak to the parent to say, hey, this is our findings now with what we have, and make a determination. And if there's additional data that you need to do when the student comes back, there's no reason not to do that as well. Like I know that there's many times you have an assessment and you'll have, you know, an additional observation. Right. And so it's the flexibility in IDEA. It completely allows for IEP teams to look at existing data that is underutilized. And so this is an opportunity to say, what is in the child's file? What is their entire history? Interview the parents at length, right? So some of the things that I've seen as cursory, here's an opportunity to do a more in-depth, and talk about, and I'd like to hear how Monica talks about, like, how do you do these types of assessments? In California, while nobody wants to be able to, you know, be within, you know, even 6 feet with another student, right, because of all the social distancing, they are part of the essential workforce too. So in an urgent or necessary need, you can conduct evaluations in person. So I know that that's something that I haven't seen, but some of the private psychologists are. So
Heidi, do you want to weigh in?
Sure. First, I think it's important that, and I don't know what the impetus of the question was, but the lack of instruction for ineligibility actually only goes for SLD. That would not actually be a tenet for any other of the disability categories under the IDEA. So if the district truly is issuing every report as ineligible because of lack of instruction, that would just be legally inappropriate under the IDEA. I completely agree with Janine. Any idea that a child, for 6 weeks has now become disabled because of a lack of instruction, I think is inaccurate. And I think Monica will even tell you is that in certain states, that neurological impairment, that IQ testing is important part of the analysis of how a child learns for specific learning disabilities. I also think that the great thing about the IDEA, and Janine points this out as well, is the creativity. If you had this circumstance, one of the things you could do as a district is to say, listen, we're going to make as part of a continued evaluation process, because right now we don't have enough information. You could actually place the child into a diagnostic placement, which is, it's not a placement under the IDEA, it's basically giving the child services as if the child had the disability to see how they're responding to it. You could make it as part of an RTI process, but there would be a way that that child could get some services as part of any evaluation process during this time period. So what we don't have, truthfully, is a situation that we have child, now from March all the way to potentially into the fall of next year, receiving no supports and services because, supposedly the data isn't available to warrant provision of services.
Could I jump in just for 1 minute? I just want to correct one sort of mild, I think, error, Heidi, in what you just said. The reading, math, and English language proficiency rule outs, which exist under section 300.306 of the IDEA implementing regulations, are not LD specific. Now, admittedly, most kids who are struggling with reading and math may be eligible as LD, but those rule outs are required for any eligibility determination where reading, math, or lack of English proficiency is part of the referring problem.
And with all due respect, Andy, it is on part of the eligibility under the SLD. We can agree to disagree on that one.
Yeah, we're going to have to. Yep.
Okay, so, and this next question, I think kind of already was answered, but we'll go into it anyway. And then I also want to mention that because we are at the point of talking about evaluations, we are getting more and more questions, and there are more and more resources being put out there around tele-assessment. So LDA is working on another webinar where we will specifically talk about tele-assessment options that might be available for school psychologists and other diagnosticians. But this next question, and we'll start with Janine, is very much related to the prior question, but this is a situation where a child was due for a 3-year reevaluation. The person notes that the reeval was already overdue. Can schools use the most recent testing to find the child eligible and waive additional testing?
So again, this is, we kind of touched on this, but it's working with the parent. If the parent agrees that, we have enough, the student is already eligible, we don't want to change anything right now, you can waive the retesting and then testing on the triennial because there's no question about eligibility. But parents reserve the right to ask for an assessment later on if they choose to. So I think as long as parents are getting the information and understanding that this doesn't change their eligibility, and the question is if there's additional eligibilities that are suspected, that would be a necessity to do additional testing. I'm not a big fan during a non-pandemic time to waive triennials, but this is not that. And this is really saying, well, wait, now let's focus on getting the student educated. And when we can do the retesting for eligibility, let's do it then.
Ready?
Yes, I mean, I completely agree with Jean. I mean, I think if you have a child who it's already overdue, I think you need to do a situation where you provide the reevaluation and provide the additional testing as soon as possible when you return to the district. Again, I think this is one of those good faith situations. We actually had this situation happen in our law firm where, you know, the question was, do we ask for an independent educational evaluation because they're already overdue and they were just issuing the report? And what termination we had, it was actually with another member of Mr. Faust's firm, was we agreed to say, listen, we'll take this reevaluation, although we don't think it's appropriate. You agree it's not appropriate, but we agree that within 30 days of them being allowed to have in-person testing, that testing's completed. So, you know, to me, there's always, if you can collaborate with the other side, a way to resolve these situations.
This question confused me a little bit. It is true that on every reevaluation, we're required to consider three things: whether the child continues to have a disability and needs special education as a result, what the child's present levels are, and what the child's current educational needs are. That doesn't mean, however, that the child's continued eligibility as a child with a disability is inevitably at issue with a reevaluation, and that our failure to be able to establish continued eligibility might mean the child is not eligible. So I'm not really sure where the question is trending. I certainly agree with Janine and Heidi, I think from what she was saying, that we may need additional testing because we're not sure whether the child continues to be eligible, or we're not sure whether a new disability label may apply to the child. And this is just one of those circumstances where we're simply going to have to reach the conclusion that we're unable to come to a conclusion and defer that to a time when we are able to do the testing and assessment.
Okay, so going to do something a little bit different here because we are getting a lot of questions from you all on the other end. So I'm going to just go out of order a little bit and jump into a question or two that we've gotten from our attendees today. And just a couple that are maybe brief answers that we can maybe address quickly, or perhaps it's more complicated than it seems. But I will address this to Heidi first, and then anyone else that wants to jump in. If there's a senior in high school that is up for reevaluation and will need that evaluation for college, how do you handle that? What is the what's the recourse for that?
Well, I'm assuming what they're looking for is being able to have recent testing so that when the child goes to college that they can get the appropriate accommodations. So, I mean, I think I would try to work with the district as soon as possible to have that reevaluation. There is supposed to be at least a notice provided to the parent of what the child's current functioning is. And at the very least, if the district could illustrate in that notice, you know, here is what the child's current function is, here are the accommodations that the child's currently needing, because that's really what they need, is some evidence to establish at the colleges that the child needs this accommodations, they continue to need these accommodations. You know, the difficulty is, you know, most colleges are not only distance learning themselves, but more likely to distance learn this fall. So, you know, it is something where at some level, it may be useful that the fact that this has happened in the senior year, because if there are some accommodations as a distance learner that child needs that we might not have known about before, the districts can, as part of this notice, provide that information.
Janine, did you want to weigh in on that?
No, I'm okay. I agree with Heidi.
Okay. Andy, do you have anything to add to that?
Yeah, I have a little bit of a different perspective on the use of the term reevaluation to refer to what we're talking about. Reevaluations, in my view, are intended to determine the child's current disability status, their current present levels, and their current educational needs for purposes of elementary and secondary education. A reevaluation is not used to determine what a child needs in post-secondary life. However, having said that, I do believe and have advised my clients that an evaluation to determine a child's eligibility for post-secondary accommodations, adult services, etc., may be a transition service that would be added to the child's transition plan and implement it as such, generating a report that that child or that child's parents can take to adult services or to a college accommodations office for accommodations. So I do see it a little bit differently, but I do see it as a transition service.
Okay, thank you. Monica, do you want to take another one of the submitted questions?
Yeah, I'll take another. So we have a question here from someone asking about what about parents collecting progress monitoring data? So who did we leave off with? Janine, do you want to give us any thoughts on that?
Yeah, as long as there is, I don't think that everything should be deferred for the parent on progress data, because that goes back to the implementation of the IEP and goals. But if they're providing the supports, I think that's great information, and parents can provide that information. And also it's a tool that I would love to see, in the future too, as parents learn how to measure their own child's progress and understand what's happening. I don't see any reason why not to have parents involved in that, but I don't think it should not have the school district not do any progress monitoring, but absolutely, if parents can do it, I don't see any reason why they can't.
Heidi, do you have any thoughts on that? Oh, you're muted.
Sorry. Luckily, a little thing pops up and it reminds me to that. No, I agree with Gina on that.
Okay. And Andy, anything to add?
No, I do agree as well. I mean, certainly I wouldn't require or let parents know I expect them to be a collaborator in progress monitoring, but if a parent did collect data, I would tell my clients, make sure they are reviewing and looking at that, especially as school resumes, to see what evidence we have of how the child responded.
Okay.
Can I add one thing about it? I think the one opportunity this has is the additional collaboration with parents, because sometimes parents bring information to IEPT meetings and it's like, well, it's not the same because it's done in the home. And this may bridge some of that, the gap that I see too.
Mm-hmm. Okay, I agree. Okay, I'm going to go back to, we do have a pretty complicated question, and I'm going to direct this first to Heidi. Okay, so a district has offered a parent in-home speech and ABA therapy, but the parent is an essential worker. They're a custodial worker at a hospital. And the mother was unable to accommodate the schedule that the school district offered. The child is being cared for by an older sibling while mom is at work, and mom clearly was not comfortable having someone come in the house when she was not there. So the mom asked for other options, including virtual therapies delivered in the early morning or late afternoon. The school has said that that is the only option available, and they have sent the mother a prior written notice asking her to waive FAPE. What are your thoughts on that one? We'll start with Heidi.
So, one of the things, because this is a difficult time period for us all. I will say one of the things I did look at was, the Secretary of Department of Education, Betsy DeVos's recommendations to, Congress in regards to waivers. And it's interesting that the tenets that she said the principles of the IDEA are built upon, one of them being the needs and best interests of the individual student, not any system should guide decisions and expenditures. She also talked about the fact that services typically provided in person may now need to be provided through alternative methods, and that any decisions, parents or recipient students must be informed and involved in the decisions relating to the provision of services. So I think, one of the things that should happen and should always happen is a collaboration between the parent and the district to try to find a creative solution situation. If it is a situation, the district is saying that this is the only way to provide FAPE, I would actually be concerned if I was a school district attorney, because are they providing any other services virtually? Because then they've just taken the position that anything else that they're providing is inappropriate. So I think that, I would go back and ask for an IEP meeting to have documentation of the fact that you have offered different alternatives to the district to provide these services, and the district was unwilling to, collaborate with the parent under any other provision of those services.
Andy, do you want to add anything to that?
This is another question where I was slightly confused because I wasn't sure whether the district was offering live service in the home or whether it was
Yes.
virtual service in the home.
No, I believe it was live service in the home.
Interesting. Okay, couldn't happen here in Pennsylvania, so it's not an issue that we've had raised yet. But let's assume it really doesn't matter whether we're talking virtual or live. It really comes around to a scheduling and convenience issue. And I'm not unsympathetic to the parents in suggesting that that's the case, but I'm not unsympathetic to the district under these circumstances with the extreme limitations that staff are working under, their own needs, again, to monitor their own children, for example, the work schedules that have been disrupted of their spouses and et cetera, make it very difficult to ensure that we can plug in staff as readily as we could in normal times to start. So I'm sort of sympathetic with both arguments here, but if we couldn't work out some schedule that worked for the family and worked for the school, the last thing I would do is suggest to my client that they have the parents sign a waiver of rights. I mean, first of all, I don't think that would have any legal effect whatsoever. We're not offering any consideration in exchange for that. So that seems like a somewhat ridiculous move. I was kind of feeling it for both sides until I got there, and I would steer away from that kind of behavior.
Just, can I just add real quickly? Yeah, I mean, I think the problem is, this is one of those cases where when we talked about flexibility with judges and comp, this is one of them that I think there's a problem because one, you're saying, oh, if you don't take X, then we're going to provide you nothing. And this parent is an essential worker. And I do think that there is a heightened protection and really making sure that understand that also tells me like we want to understand how to work with that family so that way she's able to have her child educated as well. So I think and they're also, if the district can't provide it through their providers, then they can find a contractor or somebody else that can do it through like a virtual therapy.
Okay. So we have about 3 minutes left. So that's probably time for one, maybe two more questions. So I'm going to direct this, Janine, to you first. At virtual IEP meetings, can you still ask to record the meeting?
That's a great question. Yes, I mean, there's no change. I think the video recording, I think is, I've seen I was looking at this question and, whether or not I think if everybody has permission, I think you still have to give notice of the request to record, but I see no reason why you can't record a virtual IEP. It's still an IEP.
Heidi?
Yeah, 100% agree. I mean, especially if it's for an accommodation for a parent, I think recording it is completely fine. Again, just good faith, always provide notice that you're providing the recording and in advance. Depends on your state as to whether or not the consent has to be given, but that has not been altered under the pandemic.
Okay. Andy, do you have any different perspective on that?
I would agree that the same rules apply. Generally, school districts here in Pennsylvania will allow recording when they are otherwise inclined to allow it, only if it is necessary, as Heidi suggests, to accommodate a disability on the part of the parents or an inability of an essential member of the team to attend otherwise. So we limit somewhat the recording. But I also have to support Heidi that in many states, certainly here in Pennsylvania, recording without disclosing is a wiretap and is actually a crime. So you want to make sure if you want to record your child's IEP meeting virtually or live, that you are being explicit in seeking the consent of the participants.
Okay. Thank you. Monica, do you want to just take one more question and then we will wrap it up?
Sure, I will try to do that. And I just want to remind people that we are going to try to put together a Q&A because I see that there are other questions that we are clearly not going to get to. But I saw one early on about a question about how is it that you could do an IEP, when you develop the new IEP, how do you observe a student in the classroom? Observation of the student is an integral part of the IEP. So we will start with, I forget where we left off, but how about, who wants to jump in? Anybody have any thoughts about how one does an IEP without an observation?
Well, I guess I would challenge the questioner's premise. I do agree, obviously, good practice would suggest that you should know something about the child in the actual educational setting, but of course, kids relocate from one district to another, one state to another, under all kinds of conditions under which they're entitled to a free, appropriate public education instantly from the district in question, and that district won't have had the opportunity to conduct an observation. So I sympathize with the need, but I certainly don't think that it's a fatal flaw that it can't occur.
Okay. Janine, do you have anything to add to that?
No, I agree. I agree with Andy.
Heidi, anything?
Yeah, the only thing I would add is obviously the child was attending a brick and mortar school. The classroom teacher could provide her written recollections of what she observed with him in the school at the time that he was there. I also think if there's any type of Zoom meetings or live instruction occurring for that child, she could also, provide her observations during the, Zoom meetings of his behavior. So, I mean, again, I think that exists without the actual, structured observation data.
Okay, thank you.
Great.
Yeah, and we're at the end of our time, and we will again put a Q&A document together and try to get to some of the questions we weren't able to ask today. LDA is trying to bring more webinars to our members and our interested parties out there. So if you have topics that you'd like to see us cover, please let us know. And please help us continue our work by making a donation. If you're able, you can go right to our website to do that. Cindy, do you want to say anything else before we wrap it up?
I just want to thank our panelists. Thank you, Andy, Janine, and Heidi, for your expertise and your knowledge today. We really appreciate it. It's been helpful, and we will follow up with answers to the questions we didn't get to today. So if you registered for the webinar, you can expect to receive a follow-up. So thank you, everyone, and enjoy the rest of your day.
Thank you, everyone.